crores of shares, billions in investments. But what if ownership itself can be manipulated, forged, or stolen? Imagine investors losing securities because of fake share certificates, forged transfer deeds, duplicate ownership claims, and paper based fraud destroying confidence in the capital markets. Now imagine a company failing to maintain proper securities systems, leading to shareholder litigation, SEBI scrutiny, investor panic, and complete governance collapse. Today, we are decoding one of the most transformative provisions connected with modern securities governance under the Companies Act 2013, Section 49, dealing with calls on shares accepted in good faith and its larger connection with depository based ownership systems and securities modernization. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Section 49 must be understood not merely as a technical statutory provision, but as part of the broader legal transformation that changed the Indian securities market from vulnerable paper based ownership systems into modern electronic governance infrastructure. To properly appreciate the practical significance of Section 49, we must first understand the historical evolution of securities ownership systems in India. For decades, investors held physical share certificates as proof of ownership. These certificates represented legal rights in companies. They could be sold, transferred, pledged, or inherited. But this paper based system carried enormous operational and governance risks. Fake certificates circulated in the market. Forged transfer deeds became common. Duplicate certificates were issued fraudulently. Investors frequently lost documents. Transfer registration delays created massive investor frustration. Companies struggled to maintain accurate ownership records. Corporate governance systems became vulnerable to manipulation and fraud. This historical background is extremely important because it explains why India gradually shifted toward electronic security systems and stronger depository based governance frameworks. The legislative philosophy behind securities modernization was simple yet powerful. Ownership rights must remain secure, transparent, traceable, and legally enforceable. Modern corporate governance cannot function efficiently unless ownership systems are reliable. Section 49 must therefore be viewed within this larger framework of securities integrity and investor protection. Now, let us understand the conceptual meaning of this legal evolution in simplified professional language. Corporate law ultimately depends upon certainty of ownership. If investors cannot reliably prove ownership, voting rights become uncertain. Dividend entitlement becomes disputed. Transfer rights become vulnerable. Corporate control itself becomes unstable. The law therefore evolves systems ensuring secure recognition and transfer of securities ownership. This transformation became one of the most important developments in Indian capital market governance. Modern security systems now operate substantially through electronic depositories such as National Securities Depository Limited and Central Depository Services India Limited. These institutions revolutionize securities holding and transfer systems by replacing fragile paper based processes with electronic infrastructure. This significantly reduced fraud risk and improved investor confidence. Now, let us discuss one of the most important hidden governance insights connected with securities modernization. Technology changed the operational mechanism, but not the legal objective. The legal objective always remained ownership certainty and investor protection. Earlier, ownership was evidenced through physical certificates. Today, ownership is reflected electronically through depository records. But the underlying governance principle remains identical. Investors must have secure, legally recognized ownership rights. Now let us discuss practical implications for listed companies. Listed entities operate within a highly regulated environment involving the Companies Act, SEBI regulations, depository laws, and stock exchange compliance systems. Most listed securities are now maintained in dematerialized form. This significantly improved market liquidity and settlement efficiency on exchanges such as BSE Limited and National Stock Exchange of India Limited. Without electronic securities infrastructure, modern high volume trading systems would become commercially impossible. Now, let us discuss how dematerialized systems function practically. In depository based systems, investors hold securities electronically through depository participants. Physical certificates are eliminated. Transfers occur electronically. Corporate actions such as bonus shares, rights issues, and dividends become operationally efficient. This improved speed, transparency, and governance reliability. Now, let us discuss one of the most important practical concepts: beneficial ownership. In modern depository systems, the depository may appear as registered owner for limited operational purposes, while the investor remains the beneficial owner entitled to economic and governance rights. This distinction is extremely important for advanced corporate governance understanding. Beneficial ownership concepts also connect with disclosure obligations, insider trading laws, takeover regulations, and anti money laundering compliance. Students often overlook the strategic importance of beneficial ownership structures. Now, let us discuss practical governance risks that existed before dematerialization. Suppose an investor purchased physical shares and submitted transfer documents. The company later discovered forged signatures. Another claimant appeared with duplicate certificates. Banks claimed pledge rights over the same shares. Years of litigation followed regarding actual ownership. Such situations were historically common. Modern depository systems significantly reduce these risks by creating centralized electronic ownership records. This strengthened trust in securities markets. Now let us discuss investor protection philosophy behind this transformation. Investors participate in capital markets only when ownership rights are secure and enforceable. Weak ownership systems discourage investment participation. Reliable ownership infrastructure therefore directly affects economic growth and market confidence. This is why securities governance modernization became essential for India's financial development. Now let us discuss board meeting procedures connected with securities governance systems. Whenever companies allot shares, coordinate dematerialization arrangements, or establish depository connectivity, board level approvals become important. Section 173 and Secretarial Standard 1 compliance remain highly relevant. Board minutes should properly record allotments, ISIN creation, depository participation arrangements, and investor servicing mechanisms. The company secretary plays a central role in ensuring governance discipline throughout this process. Now let us discuss ROC filing implications. Whenever shares are allotted, pass-through filing generally becomes relevant. Where resolutions involving capital structure or securities arrangements are passed, MGT 14 may also become applicable depending upon transaction structure. Though electronic systems reduced operational inefficiencies, statutory filing discipline remains critically important. Defective filings may create governance complications and evidentiary inconsistencies. Now let us discuss one of the biggest governance improvements achieved through modern security systems: faster investor servicing. Investors can now monitor holdings electronically, receive corporate benefits directly, and execute transfers efficiently. This significantly improved transparency and reduced investor grievances compared with earlier paper-based systems. However, governance responsibility did not disappear. It evolved technologically. Now let us discuss modern governance risks associated with electronic securities systems. Cyber fraud, unauthorized account access, phishing attacks, and digital manipulation have emerged as modern risk areas. While dematerialization reduced physical fraud, technology created new compliance challenges. Companies, depositories, and intermediaries must therefore maintain strong cybersecurity controls and operational safeguards. This demonstrates how governance risks evolve with technology. Now let us discuss practical due diligence implications. Investors and acquirers carefully review capitalization records, depository reconciliations, and beneficial ownership disclosures during transactions. Inconsistencies between company records and depository data immediately raise governance concerns. Due diligence teams therefore pay extremely close attention to securities infrastructure compliance. This becomes especially important during IPOs, mergers, and strategic investments. Now let us discuss secretarial audit perspectives. Secretarial auditors examine whether listed entities comply with depository regulations, investor servicing obligations, and SEBI governance frameworks. Poor reconciliation systems or unresolved investor complaints often indicate deeper governance weaknesses. This is why operational compliance quality matters significantly. Now let us discuss practical examples involving promoter shareholding structures. Suppose promoters pledge substantial shareholding to financial institutions. Disclosure obligations arise. If lenders invoke pledged shares during financial distress, ownership structures may change rapidly. Depository systems ensure such changes remain traceable and transparent. This directly affects corporate control dynamics and investor perception. Now let us discuss startup ecosystem implications. Modern startups increasingly rely upon digital cap table management and electronic ownership systems. Sophisticated investors expect transparent capitalization tracking and governance clarity. Poor ownership documentation immediately damages investor confidence. This demonstrates that securities governance quality directly influences fundraising capability. Now let us discuss the role of professionals individually. The company secretary ensures compliance with depository regulations, investor servicing obligations, and corporate governance procedures. The chartered accountant examines reconciliation statements, ownership consistency, and financial disclosure implications. The cost accountant may contribute to internal control evaluations depending upon organizational structure. Advocates advise on securities disputes, ownership litigation, and regulatory compliance matters. Registrars and transfer agents manage operational record systems and investor interfaces. This collaborative ecosystem collectively sustains trust in securities infrastructure. Now, let us discuss common practical mistakes companies make. Failure to reconcile depository records properly creates governance risk. Delayed credit of securities causes investor grievances. Weak cyber controls create fraud exposure. Improper investor complaint handling damages governance reputation. Many companies underestimate operational investor servicing compliance until regulatory scrutiny arises. Now let us discuss the relationship between Section 49 and other important provisions under the Companies Act. This governance framework operates closely with Sections 44, 45, and 46, dealing with nature of shares as movable property, numbering of shares, and certificates of shares. Together, these provisions collectively establish the legal infrastructure supporting ownership identification and transferability. The evolution from physical certificates toward electronic systems reflects modernization of this ownership ecosystem. Now let us discuss FEMA and foreign investment implications. Foreign investors rely heavily upon efficient electronic ownership systems for investment participation in Indian companies. Cross-border investments require coordination between depositories, authorized dealers, and regulatory reporting systems. Electronic infrastructure significantly improved operational efficiency for global investors. Now let us discuss SEBI regulatory connections. SEBI regulations relating to insider trading, takeover disclosures, listing obligations, and beneficial ownership reporting all depend heavily upon reliable depository systems. Without trustworthy ownership infrastructure, securities regulation enforcement would become extremely difficult. This demonstrates the systemic importance of electronic securities governance. Now let us discuss one of the most important hidden exam concepts. Students frequently study company law provisions separately from securities infrastructure systems. That approach is incomplete. Modern corporate governance must be understood as an integrated ecosystem involving company law, depository law, securities regulation, and technological infrastructure. This integrated understanding is critically important for advanced professional analysis. Now let us discuss practical compliance precautions. Companies should maintain accurate reconciliation systems, coordinate effectively with depositories and registrars, strengthen cybersecurity frameworks, and promptly address investor grievances. Operational weaknesses in ownership systems create serious reputational and regulatory exposure. Now let us discuss governance philosophy more deeply. Capital markets function because investors trust the system. They trust that ownership rights are protected. They trust that transfers are reliable. They trust that disclosures are accurate. Electronic securities infrastructure strengthen this trust ecosystem significantly. This transformation represents one of the greatest governance improvements in modern financial market history. Now let us discuss litigation risk analysis. Even in modern systems, disputes continue arising regarding beneficial ownership, unauthorized transfers, cyber fraud, and pledge invocation. Courts and tribunals increasingly examine electronic evidence, depository trails, and digital transaction records. Professionals must therefore understand both traditional ownership principles and modern technological governance systems. Now let us discuss broader economic significance. Efficient securities infrastructure improves liquidity, encourages investment participation, and strengthens confidence in corporate financing systems. Without reliable ownership systems, long-term economic development becomes difficult because investors hesitate to commit capital. This demonstrates why securities governance infrastructure is fundamentally important not merely for compliance but for economic stability itself. Professionals must therefore appreciate that Section 49 and related securities governance frameworks are not merely technical operational provisions. They protect ownership integrity. They strengthen investor confidence. They reduce fraud risk. They improve market efficiency. They support transparent governance. They facilitate capital formation. And most importantly, they create reliable legal systems through which investors can securely own, transfer, and enforce securities rights in modern corporate markets. For company secretaries, advocates, chartered accountants, CMA professionals, investors, startup founders, and governance experts, mastery of securities ownership systems and depository governance is absolutely essential because modern corporate law increasingly operates through technologically integrated regulatory frameworks. In actual corporate practice, Weak ownership infrastructure, poor investor servicing, or defective securities governance can destroy investor trust, attract regulatory scrutiny, and create years of litigation exposure. That is the true practical significance of Section 49 under the Companies Act 2013. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from Corporate and Securities Law Compass. Like, share, comment, subscribe. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.